You've been injured in a car accident. The insurance company is dragging things out. Their offer is nowhere near what you expected. And now one question starts creeping into your head. Am I actually going to have to go to trial? Because that changes things. Now you're picturing a courtroom, a jury, months or potentially longer of waiting. But here's what most people don't realize. Filing a claim or even filing a lawsuit doesn't automatically mean your case is going to trial. In fact, many California car accident cases resolve before a jury ever hears them. The more important question is this: how can you tell if your case is one of the ones that may not settle? I'm Stephen Sweat, a personal injury attorney here in California, and there are a handful of warning signs I look for when a case starts moving toward trial. And one of them can appear before anyone even starts arguing about money. Warning sign number one: they're blaming you. Imagine another driver hits you. You assume their insurance company is going to pay. Then you get their response: actually, we think you caused the accident. Now we have a problem. California follows a comparative negligence system. In simple terms, responsibility for an accident can potentially be divided between multiple people. So maybe the other driver is primarily responsible, but the defense argues that you were also partly responsible. Why does that matter? Because now the fight isn't simply how much is the case worth, it's who actually caused this. And that creates a much bigger disagreement. The insurance company may point to speed, distraction, positioning on the road, witness statements, video, or anything else they believe shifts some responsibility onto you. And the farther apart the two sides are on what actually happened, the harder settlement becomes. But interestingly, fault often isn't the biggest fight. The next issue is probably the one I see people misunderstand the most. Warning sign number two: you agree on the crash, but not on the injuries. Sometimes everybody agrees their insured caused the collision. Great, case closed. Not even close. Because the insurance company can say, yes, our driver caused the crash, we just don't believe the crash caused all of your injuries. And suddenly the entire case becomes a fight over damages. Maybe your side believes the evidence supports substantial compensation. The insurer sees the same case and values it dramatically lower. That gap matters. Because if one side thinks the case is worth $500,000 and the other thinks it's worth $100,000, somebody has to move a lot. And sometimes neither side will. That's when a jury may ultimately have to answer the question neither side can agree on. What is this case actually worth? And there's one particular argument insurance companies can use that can make that disagreement even harder. Which brings us to warning sign number three: you had an injury before the accident. Let's say your back hurts after the collision, but 5 years ago you also had back pain. Guess what the insurance company may focus on? Not just the crash, the 5-year-old medical record. They may argue your current symptoms existed before the collision or were caused by degeneration, a previous accident, sports injuries, or something else entirely. Now, a pre-existing condition does not automatically destroy a California personal injury claim, but it can create a causation battle. The real question becomes, what changed because of this accident? And that distinction can become enormously important. If your medical history says one thing, your doctors say another, and the insurer has its own interpretation, settlement can become much harder. But even difficult cases can settle. So what actually happens before trial becomes the only option, the part most people never see. Before a case reaches a jury, there can be multiple opportunities to resolve it. Initially, evidence is gathered: police reports, photos and video, medical records, bills, witness information, documentation showing how the injuries affected your life. That evidence can then be presented to the insurance company in an attempt to negotiate a settlement. If that doesn't work and a lawsuit becomes necessary, something important changes. The investigation gets more powerful. The parties can use what's called formal discovery. Records can be subpoenaed. Witnesses can be questioned under oath in depositions. Experts may become involved. And evidence that wasn't available earlier can suddenly change how both sides view the case. That's why filing a lawsuit doesn't necessarily mean we're going to trial. Sometimes it means now we can finally get the information we need to resolve this properly. And then there's mediation. A neutral third party helps both sides try to find a number they can live with. Cases can settle there. They can settle after depositions. They can settle shortly before trial, and yes, they can even settle after trial has started. because every new piece of evidence changes the risk calculation. A witness performs better than expected, the number can change. An expert gets challenged, the number can change. Opening statements reveal a weakness, again, that may change the number. Settlement isn't one moment. It's a door that can remain open for a surprisingly long time. But eventually, some cases still reach the point where neither side can walk through the door. So, what if your case really goes to trial? This is the part people tend to imagine like a legal drama. The reality is less theatrical and a lot more preparation. Your attorney organizes the evidence and prepares the witnesses. If you're the injured plaintiff, you may testify about the collision, your treatment, your recovery, and what changed in your life afterwards. The defense gets to challenge your version. Your side gets to challenge theirs. Then the jury evaluates the evidence and reaches a verdict. And yes, that creates risk. A jury can award more than an insurer was willing to offer. It can also award less than what you hope for. That unpredictability is one of the biggest reasons both sides have an incentive to settle. But there's another cost people underestimate: time. Litigation can take a very long time. Discovery takes time. Depositions take time. Expert analysis take time. Court calendars take time. And if you're still undergoing significant medical treatment, it may not make sense to evaluate the full impact of your injuries too early. So the decision isn't simple. Settlement or trial. It's often how much certainty are you willing to trade for the possibility of a different outcome. So is your case likely to go to trial? Here are the warning signs I'd pay attention to. If the other side disputes who caused the accident, if there's a major disagreement about what your injuries are worth, if they're claiming your injuries were pre-existing, if the medical evidence is complicated, or if the two sides simply see the case in completely different ways, the possibility of trial increases. But none of those things guarantee a trial, and that's the key takeaway. You don't prepare a case for settlement by assuming it will settle. You prepare it as though a jury may eventually see it. Because when the other side knows the evidence is organized, the weaknesses have been addressed, and you're actually prepared to go forward if necessary, that can change the settlement conversation entirely. So if you're dealing with a California car accident claim and wondering whether your case is heading towards settlement or a courtroom, the useful question isn't, do most cases settle? It's what specific issues in my case could prevent it from settling. Because once you know that, you have a much clearer idea of what comes next. And if you're wondering how your medical bills can affect the value of your California car accident claim, watch the next video, because the number printed on those bills may not tell you what actually is going on.